Yeah. So very good afternoon to all of you. I welcome all the participants for webinar on Intellectual Property Rights Awareness Program, which is held on 23rd December 2022, organized by Institutions Innovation Council in association with National Intellectual Property Awareness Mission NIPAM. Myself, I'm Dr. Sheikh Muzir, Head of the Department MBA, Training and Placement Officer, and convener of today's webinar. With a span of 5 days, we received more than 600 registration from different states in India. So in this regard, I thank to our management, Sri Meerawali sir, Chairman, Eswar College of Engineering, Karim Mohiddin sir, Secretary and Correspondent, and Mastan Sharif sir, Managing Director, our beloved Principal, and today's IIC President, Dr. G. Nagamalleshwar Rao sir, all the HODs, teaching and non-teaching staff for your excellent support towards this webinar. I wholeheartedly thank to today's resource person, Sri Shailender Singh ji, for accepting today our invitation. Even sir having training classes in afternoon. While we contact him, sir immediately said, okay, sir, from Eswar College of Engineering, we wholeheartedly thank to you for accepting our invitation. Thank you so much, sir. Now, I would like to invite our beloved principal and IIC President, Dr. G. Nagamalleshwar Rao sir, to grace the occasion. Principal sir. Principal sir.
Yeah. Yeah. Good afternoon, Dr. Sheikh Muzid, for arranging a very beautiful program. That too, awareness on intellectual property rights, right? So that our IIC cell under the convenership of Dr. Sheikh Muzir is organizing very useful and fruitful programs for all its students and then delegates throughout India. And today we are arranging this program in association with the National IP Awareness Program. And we are very much thankful to Shailender Singh ji, who is the examiner of patent and design industry. Yeah. Sir, I thank you very much. And on behalf of our Eswar College of Engineering, I express our heartfelt thanks to Shailender Singh ji as well, NIPAM, and also the delegates who responded overwhelmingly throughout the country. And all the delegates, right, will enjoy or will have the very great inputs regarding their intellectual property rights and everything. Actually, nowadays these IPRs are adding some credits to the faculty API scores, so that this will be very useful. Having a knowledge of this one, not only the faculty as well, the students should also have, right, knowledge of this one and aware of this one. That is why, in view of this, we have talked to NIPAM, so that we are very unfortunate enough that we are having Shailender Singh ji today with us, right, to bring awareness regarding intellectual property rights. So thank you very much. So all the delegates will right, get maximum inputs from resource person. So thank you and welcome, sir.
Thank you, sir. Principals are always supposed to me. Whenever I ask to the sir, we are doing such a thing. So on behalf of IIC and Department of MBA, sir gives me a lot of support to me. Personally, thank to our principal, sir, and the valuable support you are giving to MBA and IIC. Thank you so much, sir. Now, I would like to request and invite our college managing director, Sri Mastan Sharif sir, to grace the occasion.
Yeah, very good morning to all the participants and hearty welcome to webinar on IPR awareness program. I must thank my MBA department and IIC to organize this kind of programs. I must thank also resource person Shailender Singh for accepting our invitation and giving some awareness on this program. So thank you very much, sir, for participating in this program. And we need your support in future also. So we got a huge response for this webinar. So we make this in YouTube live also. So participants can view in YouTube also. So I must thank all the coordinators and principals, sir, and Mujib for organizing this kind of event. So please go ahead. So I think all the participants will be enjoy this webinar and have some fruitful knowledge. And thank you very much for the resource person once again. Thank you very much for giving this opportunity to me.
Thank you so much, sir. In spite of your busy schedule, you spend a time in your webinar. So thank you so much, sir. Now, I would like to request Mona Madam, IIC coordinator, to address the brief details of our today's resource person, Sri Shailender Singh ji.
Good afternoon to one and all. I feel honored to give the brief details of our today's resource person, Mr. Shailender Singh ji, examiner of patents and designs. He completed BTech in Mechanical Engineering from SRM University, Chennai in 2014. Presently, he is working as a Group A Gazetted Officer in Patent Office, Ministry of Commerce and Industry since 2016. He is a part of National Intellectual Property Awareness Mission NIPAM under the Ministry of Commerce and Industry, and he is also acting as a part of Kalam program for intellectual property literacy and awareness campaign Kapila under Ministry of Education. He delivered lectures in more than 70 seminars and national conferences in different universities and institutes all across the country. Thanking you for giving me this opportunity.
Thank you so much, madam, for your wonderful presentation about today's resource person. Now, this is the time to invite and welcome to our today's resource person, Sri Shailender Singh ji. Sir, I'm hand over in the session to you. Please carry on.
Yes, thank you for such a warm welcome, Dr. Sheikh Muziz ji. Thank you for this wonderful uh, inauguration session, and thank you to the Eswar College of Engineering for giving me this opportunity to share my learnings with all of you. First of all, a very good afternoon to all the participants, all the faculty members, and researchers from the different part of this country. Uh, First, I just want to give you some idea regarding the mission that we are uh, on doing right now in the NIPAM. Like NIPAM is basically a national intellectual property awareness mission, which was started by Ministry of Commerce and Industry just to promote and aware the people across the country regarding the IPR related to patent, trademark, designs, geographical indications. So the basic motive behind this awareness session is to make people aware about their these rights, that what are their rights if they have some intellectual property with them, if they have created something out of their knowledge, their brain, they should have the understanding that what how powerful this property can be, how you can implement this in getting the economical benefits from these intellectual properties. So NIPAM was started last year in the month of December itself, and where it was basically the thought to give awareness to more than 10 lakh students. It was the motive that we should aware 10 lakh students or faculty members in till 15th, no, 15th August. So that was our motive in the NIPAM mission. And in this, we have already completed that mission. And right now, we are just going forward to move for the NIPAM 2. And that is what we are doing in this session right now. This is the extension of the NIPAM 1, and in this we are targeting to acknowledge more than 1 crore students or faculty members so that they can aware further more people in the society. So before starting that session, I just like to share my presentation with all of you. Please let me know whether my presentation visible to you or not. Is my presentation visible to everyone?
Yes, sir, visible.
Okay. Sorry for the disturbances. Actually, there is some construction work they going out in the office. That's why maybe some disturbances might come between the sessions. So I'm sorry for that. So now is it visible to you all in the full screen mode?
Yes, sir, visible.
Okay, thank you. So first of all, we need to understand that what is the actual thing. We means what is intellectual property, why this is so much important in the present scenario. Now we need to understand one fact that in the present scenario, if you see any country, but basically India is swiftly moving towards a kind of capitalism. And in a capitalistic state, you need to understand one important fact that most people have their own businesses or their own companies or their own startups. And the government has also motivated me people uh, through many policy, through many awareness sessions, through many other programs like Atmanirbhar Bharat and Make in India. So the government has also motivated people to make them entrepreneurs for the country, to make them and provide jobs for the people. Now it's very much important for us to understand that if you are starting any business, if you are having some startup or something, you need to have the understanding related to the intellectual property. And what is this intellectual property? How you are going to get the benefit? What is your actually the intellectual property? Is it a technology related? Is it some copyright related? It is a trademark related? It is a GI related? So that we need to understand in this IP. And we also need to understand that we have seen a lot of changes in other economical changes we have seen in this country. Like earlier, we used to have only 5 to 600 startup in India, but right now we are having more than 60,000 startup in India. So this is a huge the changes that has taken place from 2015-16 to in these 5 to 7 years of time duration. So if you are starting any business, if you are starting a startup, you need to understand that it is your creative thing. If you are using your creative technology, if you are using your maybe it's a different business, if it is a different trademark, if it is a different technology also, then you need to understand that how you can protect it and why you should protect it. because you need to understand one important fact that there are, if you start any business, there are other people also in this competitive world. And if your work is very much get popularity in this so if your business get popular in this market, and then maybe other people will start copying your thing. They will start making the similar business. They will start having the similar products, selling similar products. So you need to have the exclusive right over your creative work. So that is what we need to understand in this intellectual property this session. Now we have multiple types of intellectual property, like we have patents, design, trademark, geographical indication, copyrights, and semiconductor integrated circuit layout design. So these are the different categories under which you can register your work. Now you need to first understand that what is your intellectual property, and under which category it's falling, what are your rights in that, and how you can differentiate between these different intellectual properties. Now, just to give you an idea that if you see any product in the market, now this is a product that is very well known to many people. Like it's a Apple laptop, which is introduced by this Apple company. Now you need to understand how the company protect their technology or their product. Now you need to first understand that there can be multiple intellectual properties also in a single product. So it's not like that if you are filing anything in patent, you can utilize it the same thing along with the design. No, you can utilize it with the design as well. So it's just an example to make you aware and make you uh, know that in this particular laptop there are multiple intellectual properties, like you can see here. Like all the technologies that is used in the laptop is basically a patented technology. Now the outer case of this laptop is a design protector. Now the logo of this laptop is a trademark registered thing. Now the user manual, the programming algorithm that is used in this laptop is a copyrighted material. Now another is the SICLD, that is the electronic plate inside this laptop is a SICLD design protected. So from here you can easily identify one thing, that each and every part in this laptop is protected. Now if you see that there are so many multinational companies, so many tech companies in the market. Along with Apple, we have HP, we have Dell, we have Lenovo, we have many other companies. Now we need to understand that these are competitive. They are very much competitive, and they are always interested that if something new came into the market, then what they can make out of it, how they can utilize the others technology. So it's very much important that if you are coming into the if you are bringing your product, if you are bringing your technology into the market, then it's your duty to have the protection. And this is what all the companies do. They first file these different IP in the different category, and then they bring their product in the market. Now what is the importance and significance? You need to understand that it will protect your work, it will protect your creative intellectual work, it will exclude others from doing any economical activity without your consent, and it will also help you in utilizing, commercializing, and earning from them. Now very much important for us to understand that how it can be beneficial to the different section of the society. Now, right from the starting, I was talking about the business. I was talking about, if you are starting a business, if you are starting a startup, if you are having any company, then you need to understand that it's very much obvious that for a business point of view, it's very important thing. Why? Because it will help you in commercializing, brand creation, earning, and getting more investment from them. That now how it can be beneficial to a common person. Now here common person, I'm talking about the researchers, maybe maybe the professors, maybe the faculties, maybe the students. So how it can be beneficial for them. Now in the starting itself, that principal sir has also mentioned that these IPR are very much beneficial in your academic career also, because you get some benefit in some maybe rewarded, or maybe you get better position in the institute. If you see any person in any institute, like if you see any university, if any renowned institute, then the dean or maybe the principal or maybe the HOD or chancellor, vice chancellor. So these positions are held by those people who have multiple IPs, who have multiple researches, who have multiple copyrights. So these are very much important for all these person who are in the academic field as well. And it is also beneficial to the students as well. Means if I talk about the student, then you need to understand one thing, that let us assume that right now what we are learning, we only learn the things which are written in the book, but we don't know how to implement that information into day-to-day life. So uh, these different IPR usually reflect the projections that if someone has one patent, let us assume that one student has a patent or they have filed a patent, it means the people who, if they go into any industry for the interview or maybe any company for the interview, then the people will definitely show some extra interest in that particular student or maybe in that person. Why? Because that will create a thought in the interviewer's mind that yes, that person is having a patent or maybe he has or she has filed a patent. So it means he or she is a very creative person or maybe an innovative person and can be beneficial to their R&D or maybe their company's innovative work. So it's very much beneficial to all different sections of the society. But it's not wrong to say that the direct beneficiaries are usually businessmen. But it's not like that you, if you want, you need to understand one thing. You if you have one patent, let us assume that it doesn't make you that it doesn't ask you to sell the product into the market directly. You can also sell your technology to any company. Means you do the research, sell your technology directly to the companies. Now basically this is the concept of technology transfer that we use in this world, that we, there are some companies, there are some institute also where the people do researches and uh, they sell those researches, they sell those patents to the different companies so that they can directly implement into the day to day life. So that is also possible. If you are not interested in doing the direct business or direct commercialization activity, you can directly sell your technology or maybe your researches to the people who are interested. Now, first IP that we need to understand is the patents. Now, what is a patent? Patent is first of all a state or a sovereign right. It means if you are filing anything in India, it will only be protected in India. So, first thing you need to understand that it is a territorial right. Now, if you assume that how any company does their business, they file patents in multiple countries. Means they first identifies that in these countries I am going to do the business, or I want the protection in these countries. Then they first choose those countries and file the patent in all these different countries. It's not like that they are going to file the patent only in a single country and they will have the protection all across the world. No, it's not like that. It's a territorial right. So if I talk about let us assume that uh, any popular company like Honda. Now Honda is a car company. Now Honda is a Japanese company, but they will file a patent in India, Japan, Australia, UK, US. Why? Because they are selling their product in these countries also, and they know that there are companies or there are industries which are working in the same field as well. So they do not want others to copy their technology. So they file the patent in all the different countries where they think that they should have the protection, or they need to do the business over there. So sometimes we see that some researchers what they do, they file the patent in any other country. Maybe they file the patent in uh, Australia or maybe Germany, and after that they understand that it is not protectable in India. You will not get any protection in India. So you need to understand one thing, that if you are going to do any business in India, or if you are going to do any, if you are going to sell your technology in India, or maybe your research in India, you need to file the patent in India only. If, yeah, if it is okay, then you are going to sell the technology or product in any other country, then it is okay. If you are thinking that you are going to sell the product in multiple or technology in multiple countries, then you need to file the patent in multiple countries. So you need to understand this fact. There is nothing like a global patent or an international patent. That is the first myth that I just want to clarify, that people have a thought in their mind that I have a patent over this thing, then it is protected all across the world. No, it is nothing like that. So that thing we need to understand first of all. Now, second thing is that patent protection is given for a period of 20 years. Now, if you have filed anything for a period of today, then it will be protected for the upcoming 20 years. So, that is the first thing that another thing that we need to know, that after 20 years, you don't have any exclusive right. You can, whatever, if anybody wants to utilize your technology or product, they can utilize it without your consent or permission. So that is. Now we need to understand another fact which is related to the inventions and innovation, that most of the people have a thought in their mind that that most of the researchers and all the other technologies and other things are already being introduced by previous researchers or maybe previous scientists, so there is hardly any scope to create anything new. So that mindset we need to change. We need to understand the concept of innovation. Like usually what we see that, well, when anything is invented by someone, like Graham Bell has invented something or Wright brothers has invented aeroplane. Now they have invented that particular thing as per the requirement of that particular time zone, and at that time this type of technology was useful. But right now if you see and utilize the same phone that was developed by Alexander Graham Bell, nobody is going to utilize that. Why? Because the technology has changed, and there are so many innovation has taken place in that particular technology itself. So these are the innovation that has taken place in those technologies. And you need to understand one thing, like just take the example of telephone. Now in telephone industry we can see that earlier we used to have PNT, that phones with the wire and all. Now those phones are used in the time duration between 2000 or nearby that time, or before that time also we used to utilize that type of device. Now after that we came across with some different thing, that is cordless phones, where we can put take the phone to a range of 50 meters or 100 meters. So that was the innovation that has taken place. After that we came across with mobile phones, so that was very new between the time of 2000 and 95 or 2000 to 2005, where that was a new thing. Now after that we came across with that telephone, that mobile phone has changed from keypad to a touch screen. Now in the touch screen we used to have single sim phones, now we have dual sim phone. Right now we are having eSIM technology, where we do not need any sim, we can directly utilize the phone just by registering our sim uh, through the e mode. So we need to understand one thing, that with the change, with the passage of time, the technology changes a lot, and these changes are basically innovation. We, all the products which are being, or all the technologies which are introduced right now, they have some flaws, or there is a requirement to make changes in that technology. So these changes that is taking places, or maybe the problem that we are solving through any technology with that product only, is basically the concept of innovation. We can innovate new product out of same invention. So that is what we need to understand. And these innovations are basically filed for the patent. Because if you see any well drafted any document in a patent application, you will find out that people usually draft the application in such a way that there is a column like disclosure related to the previous prior art. So where they always disclose that this is the prior art. Prior art means previous technology, where this is the flaw in that technology, and we have added this type of new technology in this, which is solving this one, and now they have this new product with this solution. So this thing we need to understand. Now We can also create new products also. Now this is a very nice example of how we can create a new product. Now this product is solving a problem of uh, infants getting irritated. They feel irritated when the soapy water get into their eyes, so they feel irritated. So to solve that problem, this hat is protecting their eyes. So it's a very nice example that how you can also create new product. Now, just to give you an idea that each and every company, whether it's a government institution or a private institution, they will file a patent before the government, so that they should have the protection. They should have the monopoly or exclusive right over their work. So it's not like that only the private institution have to file, even private as well as the government. If you want a monopoly, there is no exclusion. Each and everyone has to file a patent for that. Now, patent application filing. Now, maybe there are so many people who have already filed the patent, or maybe they filed it difficult when they try to file the patent, or they found out that there are more than 30 forms, or around 30 forms are there in the application. Which form is to be filed, which one is not required, which one is required. So usually they take the help of any agent or attorney for filing the application, and after that they say that we are not able to file the application because they are charging a lot. So first of all, first thing is that it's your duty, whether you it's your choice, that if you want you can file by yourself also, but if you want you can also take the help of any attorney or agent who are already registered under the patent office. So you can also take their help also for filing the application. But if you are interested in filing by yourself, you need to understand these forms. So these forms are 1, 2, 3, 5, and 18. Now you need to remember these forms, that if you are interested in filing any application, you need to file these forms. Without these forms, your application will not be processed further, because these are the mandatory type of form that you need to file these forms. Now these forms are form 1. Form 1 is basically a form in which you need to disclose the application or applicant's detail. Form 2 is basically a form in which you need to disclose about the description. Now description can be in two modes. It can be in the provisional specification and can be in the complete specification. Now what is provisional? Provisional means if you are working on any technology and you think that I need some more time to complete this technology, but if I share this information with anyone, they might copy it and they may file a patent before my filing. So what you can do, you can do one thing, you can file a patent application with the provisional specification. Now the government gives you one complete year to file the complete specification and submit it within that time duration. Now you can also file the complete specification in the starting itself, means you can file the complete specification and you need not to wait for one complete year. So you can file 1 2 on a single day itself. Now, Form 3 is basically a form in which you need to disclose about the foreign filing. Means if you are filing any application in any other country, let us assume that you are filing any application in Japan or China or US or UK, then you need to disclose this information that I have filed a similar application in these countries also, and you need to update that in the prescribed time period. Now, Form 5. Form 5 is basically declaration as to inventorship. Now, declaration as to inventorship means who are the inventors in your application. Now, if you have submitted any application, you need to disclose this, that these are the inventors in the application. Now, sometimes what happens while let us assume that someone has submitted provisional specification and there were two inventors in the application, but they might require one extra person who knows some information which is not known to them. So they took the help of that third person, and the third person said that I will help you out in that particular application completion, but I will want to become a co-inventor, because I have helped you in the completion of this technology. I have told you this information, or because of that you have completed this. So maybe in between the process there is an addition of the inventor. So So in that case, you need to, that is why while before whenever you submit a provisional specification, you need to understand that, because after submitting the complete specification, office don't know that who are the actual inventors. So that is why we need this information with form 5, that you need to declare about the inventorship, that who are the inventors. Now after 1, 2, 3, and 5, your application goes for the publication purpose and it gets published. Now in publication is only for the purpose of the pre-grant opposition, means we usually publish these in the we publish all the applications which are submitted in the Indian Gazette. And you need to understand one thing, that these publications are being done so that other people in the same domain, or maybe the same similar industry, they can understand that what type of application or what type of invention has been filed by the applicant. Because they usually keep on checking the different inventions which are filed in a similar domain related to their company only. Now for that purpose, this publication is being done. Now in the publication, the only purpose is that what I have disclosed, for disclosing the information to the public domain, and so that we can accept the pre-grant opposition. Like if someone has someone says that the similar invention I am using in my industry, or maybe similar invention is already there and I know about it, and so so we can file a pre-grant opposition against you. So for that purpose only we have these publications. But some people in the academic world, they have a thought in their mind that my application got published, it means that my patent is going to get granted. So that is the one important thing that we need to understand. The publication has no relation with the information related to the grant or refusal of the patent. Why? Because each and every application will go for the publication, but you will get to know the information regarding the grant after the examination process is over. So nobody can say that my application is published, it means I am going to get the patent. So only those applications which qualifies the process of this examination, where they have gone through a technical and uh, uh, formal checks and all other things, where they qualify the novelty, inventive step, and industrial applicability. These are the three checks. If they qualify all these three checks, then your application will go for the further process. Then your application will go for the granting process, else it will be refused. So these are the things that we need to understand, that publication does not give any information related to the grant and refusal. Now examination process takes place after the publication, and form 18 needs to be submitted for the request of examination, and that the maximum time period for the request for examination is 48 months. Now form 1 is this is the fee. Now form 1 needs to be submitted along along with these are the form. The another fees is the form 18, that is 4,000 rupees. Now the category is for the natural person, startup, small entity, or education institute. This is the fees, and for others the fees is 8,000 and 20,000 rupees. Now submission of the patent application, there are two modes. One is the e-filing, and that can be done anywhere from the across the world. You can submit the application. This is the website, that is ipindiaonline.gov.in. Another one is the hard copy filing. You can submit the hard copy directly to the patent office. Now that are situated at four different locations: New Delhi, Mumbai, Kolkata, Chennai. You can submit your application there also in the hard copy mode. Now this type of page will open if you want to submit any, if you want to do a e-filing of the application, then you need to sign up, and after signing up, this type of page will open and you can log in and see the different forms. Now the expedited examination. Basically expedited examination is for those purpose that sometimes someone don't want any delay in the complete process of this patent grant and refusal. So they want to know about the status and all at the earliest. So what they do, they go for the expedited examination, and where they get the priority over other normally filed application. So in this expedited examination, we can get the patent maybe in a year and a half, means in 18 months to 2 years at max. Usually people get the patent information that whether they get the patent granted or it's getting refused. Now, these are the category who can go for this expedited examination process. These are startups, small entity. If any of the applicant is a female or maybe a co-applicant is a female, then you can go for the expedited examination. If you are a government organization, then also you can go for the expedited examination. Now, the screening and classification, there are some applications which are not which directly does not get approval before these applications are being examined or published. Then before that they are being sent to the concerned authority. Now if your application is related to the atomic energy or defense, then your application will go for the will be sent to the atomic energy department or DRDO respectively. And after getting the approval from them, if they approve it, then your application will be processed further. If they do not approve it, then your application will not be processed further and it will go abandoned. Now the examination process in the patent application examination is basically two types, two tier, that is formal and technical. In the formal we check usually all the forms and all the features. In the technical we check the this is the in the technical we check all the specification details, and we usually check what is the inventive step, what is the novelty, is it industrially applicable. So we check all the things in the technical examination. After doing the examination, we go for the FER. We send you one FER, that is first examination report. It will consist of all the objections and all the communications. Now this is being sent to you. Now you have 6 months of time. 6 months if time is being given to the applicant to give us a reply on that FER. Now after getting the reply from the of that APR. After getting the reply from them, we do the re-examination, and all the things are being checked again. If all the objections and all the things are met properly, all the things are properly replied and explained, then your application will go for the grant process. If there are still some pending issues, then we will ask you for a hearing. In the hearing, we will have a technical discussion with the pending issues. Now the pending issues, if still in the hearing also you are unable to explain the things, or maybe you did not able to clarify the objections mentioned, then your application will be refused. If you have explained properly, then it will be granted. Now the provisional specification to complete specification, time duration I have already told you. So this is basically the timeline of the different forms and different replies and other things, like 12 months, request for examination 48 months, FER reply 6 months, form 3 6 months. So these are the time limit. Now the second IP that we have is the designs. So design is basically IP that relates to the aesthetics of the products. Means if you see the outer case of any products comes under the industrial design registration domain. Now, what is industrial design? Industrial design basically a shape, configuration, pattern, ornament, composition of lines, which are solely judged by the eye. So whatever we are seeing through our eyes basically comes under the industrial designs. Now, what is the term of protection in the industrial design? It is 10 years and it can be extended up to 5 more years. The total time is 15 years. Now, just to give you an idea, let us assume that I want to buy a car which cost around 10 lakh of rupees, and I have given some specification that car should have 10 cost and around 10 lakh of rupees. It should have 1500cc engine. It should belongs to Maruti company. Then these are the details that we need. Now these are the details that I have given for the specification purpose, and I want to buy a car in that with these uh, things only. Now what I do, there are three products that I have under these specification, that we have S-Cross, we have Artica, we have Brezza. Now they have the similar specification, like they cost around 10 lakh, they have 1500 cc, they belongs to Maruti company. Now some of you will say that I want to buy Brezza, some will say I want to buy S-Cross, some of you will say I want to buy Artica. So how you have made your choices? On the basis of the outer looks of the product. So that is the thing that we need to understand, that industrial designs covers the aesthetic parts of any uh, thing. Now the the fees is 1000 rupees for the individual startup and small entity. For others, it's 4000 rupees. Form 1 needs to be submitted. These are the details in the form 1, like name, nationality, address. These are the details that you need to submit in the form 1. Now also one another thing, you need to submit the 2 sets of illustrations of drawings. So whatever drawings are there, you need to submit the 2 copy of each. Now this is the specimen sheet of the design thing. Now in the design registration, now novelty of the product means newness of the product is being checked only on the basis of the shape and the configuration. Now it's a teapot. Now we need to understand this teapot can have multiple mechanism or multiple features, or mechanical features or things, or maybe principle of construction is very different. So these are other correlated things with this particular same product. Now we cannot have any claim by virtue of this design registration related to mechanical feature, mechanism, or principal mode of construction. Now because these parts or these things are covered in the patents. Now in the design you can only have the looks related protection. This protection you can only get in the patents. Now the next IP that we have is the trademarks. Now the trademark is basically any word, name, symbol, or device, or maybe combination of all of them, which help us in identifying, distinguishing the source of goods and services of one trader to that of other. So basically trademark is a trademark is basically a identity of any company. Now if you see that trademark is beneficial to both sides of the economical activity. Means if we see that in any economical activity we have either consumer, another one is a trader, or maybe a service, maybe a seller, maybe a manufacturer, maybe a fabricator. So there are 2 sides. Now for a consumer it's very obvious that it will help them in identifying the product, because how I can identify that is, if I want to buy any t-shirt from Adidas, how I can identify on the basis of this trademark only. I will go into the market and I will find out that where is the Adidas showroom, and on the basis of that trademark sign of Adidas, I can see that this is the original product of Adidas and I can buy that. So this is how I can identify the thing. Now, another thing is that for any business person, it's very much important. Why? Because business or maybe any company's identity, or maybe the goodwill, or maybe the reputation of the brand is basically based on this trademark only. If you are working really well, if you are providing really good services to the public, then people will have a different status in their mind that this company is providing really good services. You will refer other people that you can use these services. So how you can give this how you can protect this identity through trademarks only. Now let us assume that I don't have any trademark over my company's name, and my company name is let us assume that XYZ Technologies, and I'm providing some services related to the computers. Now, maybe I got popular in the market, maybe in the city, maybe in a state, but other people start thinking, yeah, this XYZ Technology is really much it's really good and they're providing really good services. Maybe some other person comes into the market who opens the similar type of services with similar name, XYZ Technologies or say XYZ Tech. Now people will get confused that which is the original one, which is a fake one. So it's very difficult for people to identify because you do not have any trademark protection. So it is why very much important for you to understand that first it will create two different type of losses for your company. One is that your business is going to be divided into multiple, means earlier you are the only person uh, to whom the people are coming for getting those services. Now there are two different companies and people are going to the fake one also and the real one also. So that income has distributed. Now another thing is that let us assume that the fake company is providing bad services. Now your identity is getting bad reputation in the market. Now people have start saying that the earlier they are providing really good services, right now they are not providing the services that they used to provide us. So this type of mindset will come into the people's mind, and this will also create a loss to your business. So this trademark protection is very much important for all the people who are going to start their business. There are different subject matters that come under a trademark protection, like trademark, trade name, collective mark, certification mark, tagline, slogan, shape, sound mark. Now, how you can identify the trademark? Now, there are two things. One is the registered trademark. One is the pending application is filed, is still pending, or maybe some process is still going. Then the TM is written over the company's name, and if it is already registered, then R is written over the company's name. Term of protection in the trademark is 10 years. So if you are filing anything today, it will be protected for the upcoming 10 years. But there is another thing that you can further renew your trademark for the indefinite period of time that you, but you need to understand one thing. You need to, before the end of each 10 years tenure or cycle, you need to refile the application, or you need to renew your license. So that is you need to do, but you can proceed, or you can further extend your that trademark protection for the indefinite period of time. The only thing is that 10 years cycle has to be, you need to remember that you have to renew your license before the end of this 10 years tenure. Now the copyrights. Copyright is basically a right which is given to the author, or maybe a proprietor. Proprietor maybe we usually call it to the owner of that particular work, creative work. So with different type of creative work that comes under the copyright protection are literary work, artistic work, dramatic work, musical work, sound recording, cinematographic films. So these are the different work that comes under the copyright protection. Now you need to understand, because there are different categories. So the in the copyright we have the different time duration or different time protection in the different work. So maybe in the literary work we have uh, now in the literary work, or maybe dramatic work or musical work, we have life of the author plus 60 years. For cinematographic film sound recording we have 60 years. Broadcasting we have 25. Performance right we have 50 years. So they are different category, we have the different term of protection. Now the filing of the copyright protection, you need to submit form 14 along with the material whatever you want to have protected in the copyright protection. Like let us assume that you have sung a song and you want to protect that, then or you have written something, then you have to provide that written material, or the sing that CD with the song, that those things you need to provide us along with the form and fees. The fees is for the different category, we have the different fees. Like literary work we have 500, artistic work 2000, sound recording 2000, and cinematographic films is 5000. Next is the SICLD. Now there is a thought in many people, and I have heard so many people with the query that why this SICLD, how this SICLD is different from the patent. It looks very much similar to the technology related thing, but it is not like that. You need to understand this thing. First thing is that the second half of this word SICLD, LD means layout design. So what is a layout design? Layout design, if you see any circuit, there is a layout in it. Means there is a positioning of input, output, something, maybe positioning of the transistor, maybe the positioning of the diodes. So the different parts are being positioned at different positions. So this positioning are being protected in this layout design. Now, why this protection is being given? Now, what is, first of all, we need to understand what is a layout. SiC. SiC is a semiconductor integrated circuit, which is a combination of different transistor and other circuitry element, and combining all of them, we are performing some electronic circuitry function. Now this electronic circuitry function is giving out some output. Now let us assume that I am giving the similar output at in a lesser space. How I have given some different layout design, and I within which I am getting the similar circuitry function. So it means you have created an innovative design. So this layout, that innovative design that you have created, maybe earlier you might require this 6-inch mobile case for providing all these features or all these outputs. Now you can give similar features, similar outputs in just 3-inch mobile. So it means you have created a different layout design which is providing all the similar features which the 6-inch SiC plate is providing. So that is why this SiCLD, this layout designs are protected. Term of protection of SiCLD is 10 years. Fees is 5,000. Now last IP that we have is the geographical indication, that is GI tag. Now GI tag is basically is the identification that identifies a product that have a specific geographic origin and poses a quality or reputation that are due to that origin only. It means if you talk about that there is a word geography in that geographic indication. Now this geography means it relates to a particular location. Now why this has came to the picture? Now this geography has came into the picture because of some reason that maybe because of the climatic condition that is helping this product to grow, or maybe providing this essence or quality to that product, maybe the soil, maybe other factors like traditional knowledge that people have in producing that product, or maybe the art form of those local people who know that this is how it is going to be made. So these are the factors which are related to a particular geography only, and this identity is given to those people, those community, or those first of all, this right is not given to any individual. It is given to any organization, any community, any state, city, like this. So this protection is not only providing them a better value for the same product, it is also giving them popularity all across the world. So the two benefits they are getting from this GI tag. Maybe earlier their product is costing 50 rupees. Now with GI tag, with the identity that this is a very different product from, and it has a special quality. So maybe right now they will get 500 rupees for the same product. So these are the examples of the GI tag like Darjeeling tea, Makrana marble, Ratlami save, Kanjipuram silk. So these are the art forms that have different from different locations. Many edible products like pan, mango, oranges, lychee, saffron. So these are the different GI. Now just the summary of the different IPR. Patent protection is for 20 years. There is nothing like global or international patent. The design protection is for 10 plus 5 year. Trademark is for the indefinite period. You only need to renew it within 10 years cycle. Similarly, GI is for the indefinite period, same as trademark. Copyright, we have different term of protection for the copyright for different work. Now, who can apply? Anybody can apply for the different IPs. Only the case is different for the GI. Individuals cannot file the GI. So that was all about the presentation part. Now, if you have any queries or any questions, you can ask me now.
Thank you, sir. So there is a extreme presentation from today's resource person, Shailender Singh, sir. So many of things known by you with today's presentation. So now I would like to request from the participants, is there any question and answer session? You please carry on. Okay, you just raise your hand so that I'll try to unmute. Okay. Srinivas, sir, please, you may continue.
Good afternoon, sir.
Yes, good afternoon.
Shailender
Please,
sir, indeed it was a very value-added presentation where we have got a lot of intellectual inputs regarding the IPR filing and publication as well as grant. So I would just have a small request on
please.
behalf of all the social science and management faculty fraternity. So generally, whenever we think of patent, we generally the technological patents comes into mind where there is something innovation, something to be discovered or innovated. So can you just throw some light on how well we can, how easy that it is to file a patent in social science and management background?
Yeah, actually, your question is really good. But first thing that I just want to add on in that is that uh, we usually think in a very limited way of thinking. Our way of understanding things are very limited. Now, when you ask things related like that, how you can file a patent in this particular field like social sciences or maybe management or something related to that, you need to first understand that patent is not a branch or field specific. You can create any product from any field. If you think that if this technology can be useful, if this product can be useful to the society, then you can make the similar you can create any new product which can help in solving that problem of the society. So it's not, first thing is that it's not branch specific or field specific. Now there is one another thing that you need to understand, that we have seen so many patents where there is one person who is actually not the inventor, but because of his inputs that he has given to the people, like maybe we have seen so many applications from the medical field where doctors are actually not the people who have invented that device, but they have given that information that these changes we require in this particular product, and this is how these changes can be made. Now implementation part goes to the engineer. Now in collaboration with the doctors and engineers, they have created and developed a new product. Because if let us assume I am a dentist, then as a mechanical engineer I don't know what type of products and devices are used by dentists, and I don't know what are the problems in that particular product. So uh, that problem is being identified by, can only be identified by a dentist only, but dentists don't know how to make this thing. So dentist will help us out in solving that problem in a way that this is the problem in that, and this is how we need this type of solution. Now this solution can only be provided by in collaborating with engineers. Now coming up to your question, now you are talking about the social science or management related things. Now maybe because directly your fields are not too much related to the science and tech, so you may be finding it difficult, but you can create something like in science and in the management we see so many different algorithms, we see different uh, ways of performing some particular task. Now you can also create some algorithms or some other devices, combining that device with that algorithm you can create something new which can solve the problem of the society or maybe the prior art, and you can develop new product this way also. So directly I cannot say that this type of invention can come, but yes, you can help out in another way, like you gives multiple solutions saying that some practices or maybe some algorithms you say that these type of inputs or these type of things we require. So now you can do one thing, that using that algorithm or ways you can create a device, and combining with that device you can develop, file for a patent and have patent over it.
Thank you, sir.
Yes.
Next, 21 JE 5A0304. Unmute your mic. Okay. Is there any questions from participants? So I request all the participants, if you people having any sort of questions, you please just raise your hands so that I'll unmute your mics. Sir, someone asked to share PPTs.
Okay, sure. I'll share the PPT with you. You can share with them.
Fine, sir.
So in the end, just if there's no query, I just want to say that please, if it is possible, please open your screen. I want to just take one snapshot of the session
Okay.
for my official purpose. Can you
Fine,
please,
sir.
all
Yeah.
the participants, I request to please.
See, all the participants are requested. I'll give the. The participants can unmute, on your videos. Just a minute, sir.
Okay. Yes, thank you. Now you can switch off your videos. Thank you. Now, one another thing. If anybody is from any other institute or any other organization, and if they are interested in organizing this event in their institute also, they can also get my contact from Dr. Sheikh Muziz sir, and they can directly contact me for organizing this type of event in their institute also. So if you want to, if you are from any other institute, you can just contact me and we can arrange this session in your institute as well. Okay, I think we don't have any query now, so I think we should end this
Yeah.
session.
Sir, 1 minute, sir. So this is the time to give vote of thanks. So now I would like to request Mrs. Sheikh Shahnaz Madam, Assistant Professor, Department of CSC, to propose vote of thanks.
Good afternoon to all. Myself, Sheikh Shahnaz, Assistant Professor in CSC Department. I deem it a great honor to thanks to all who have helped us in making this webinar such a resounding success. First of all, I would like to thank our distinguished speaker, Shailender Singh sir, for making excellent presentation and making this webinar interesting and meaningful. I would like to express my profound gratitude to our Chairman Miravali Sir, Secretary and Correspondent Karim Mohidin Sir, and Managing Director Sheikh Mastan Sharif Sir, and Principal Dr. G. Nagamaleshwar Rao Sir, and convener of this webinar, Dr. Sheikh Muzir Sir, presence in this webinar. I am happy to express thanks to our staff members who have made this webinar a grand success. I thank all the people who have participated overwhelmingly and making the event successful. Once again, I thank all for your cordial cooperation. Thank you.
Thank you so much, Madam. Sir, thank you so much, Shailender Singh. So,
Thank you, sir. Thank you.
so the feedback link will be sent within 1 minute. So you please, all the participants are stay in chat. So within couple of minutes, I will send you feedback link. Just now I shared feedback link in chat box. I request all the participants, you please fill the feedback and then only we consider as attendees. The feedback form will be activated up to 15 minutes only, 10 to 15 minutes only. So I request all the participants to fill the feedback form as early as possible. See, once more, I thank to today's chief guest, Shailender sir. Somebody asking feedback form in YouTube link. So I'll be shared within couple of minutes. I request to all the participants, those who fill the feedback form, you please left from the meeting